All right. Good morning, sir. I'm Judge Epperson. How are you doing?
Morning, sir.
Can you please state your name?
David Kibbley.
All right. We're here for your initial appearance, and counsel, if you could announce your presence.
Roger Whedon.
All right. And the state attorney's office, represented by Ms. Tyner, of course, today. I have reviewed the police report. I do find probable cause for the listed offenses of trafficking hydrocodone as well as driving under the influence. Before determining bond and conditions of release, hear from counsel. Mr. Whedon.
Yes, Your Honor. As you saw in the affidavit, Judge, this is based solely upon quantity, not based on any kind of allegations of distribution or past distribution or intent to distribute, just solely on quantity. And I'd like to inquire of my client, Your Honor.
Okay. Well, briefly, Mr. Is it pronounced Kivili? Kivili. Please raise your right hand to be sworn. You solemnly swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right. And the reason I say briefly, at initial appearance, I typically take proffers, but to have a full-fledged bond hearing, due process, we would typically schedule it within 72 hours. So this will be brief. Yeah.
It'll be brief.
Okay. Go ahead.
How old are you, sir?
I'm 56 years old.
How long have you lived in Central Florida?
32 years.
Where'd you move here from?
Connecticut.
What's your educational background?
Associate's degree. 4 years in high school and 1 year in college.
Okay, and do you have any special training?
Yes.
In what area?
Automotive technology.
Could you speak right into that microphone? Yeah.
Automotive technology.
And what area of automotive technology?
Jaguar cars.
Okay, do you have your own business?
Yes, sir.
What's the name of your business?
The carport specialist of Belle Isle.
Okay, how long have you been in business over there?
32 years.
Do you have any prior criminal history?
I've never been convicted, no.
Well,
I can't hear you.
I've never been convicted of a crime, no.
well, you have a conviction from back 25 years ago for theft, correct?
Petty theft, yes, correct.
Okay. And anything in the last 25 years?
No.
Do you have employees at your business?
Yes, sir.
How many employees do you have?
I have 2.
And are they dependent upon you to run the business?
Yes, sir.
Do you have any residents anyplace else in the United States?
No.
Judge, I'm going to do something too that I would normally never ever do, and that's inquire my client about the charge.
I don't want to get into the facts of the case right now. If you want to have a full-fledged bond hearing, you can do that, but I really don't want to get into the facts of the case today. You said 20 years ago. I'm showing the conviction was 2012.
12, 13, I think.
That was a petty theft.
Right. I thought he said 20 years ago.
Well, he did have a grand theft 25 years ago,
Mhm.
and that's the only felony he has on his record. And the petty theft was about 12 years ago.
Okay. All right. But you can make a proffer about the case, the facts of the case,
Okay.
if you wish. Go ahead, Mr. Whedon.
Yes, sir. Judge, as I indicated, this is based solely on quantity in the vehicle. The proffer is that the drugs, the hydrocodone belongs to employees of his that he transports around. He left the hydrocodone in his car. And we think this case is going to resolve based on the testimony of, his name is John Grady?
John Gregory.
John Gregory, who was the employee, and as you saw in the affidavit, he told the officers that it was John Grady's hydrocodone. So given the fact that he's lived here for over 30 years, he has a substantial business here for over 30 years, he has employees, he doesn't have any residence anyplace else. The sole purpose behind a bond is to make sure someone appears in court. And so we think $1 million bond is just totally inappropriate for a case of this nature, which is based purely on quantity, for a person there's no evidence of drug dealing, et cetera, who has strong ties to community, his own business here. And I'd ask the court to reduce it to $25,000 bond.
Ms. Tyner.
Your Honor, I looked up the schedule, and what I'm seeing is that the $1 million bond comes straight from the bond schedule. I understand that's not statutory, but that is what Orange County bond of this charge typically is. I just want to bring to the court's attention, he actually has no felony convictions from what I saw, so I didn't want that on record. But I do see that he had $2,730 on his person, and that the pill bottle did not have a name on it. So we just ask that you take that into consideration when setting the bond.
All right. As counsel indicates, one of the primary reasons for bond is to ensure one's appearance in court. And one of the relevant factors in making that judgment has to do with prospective penalties. That's one reason, I guess, the administrative order has a $1 million bond as a standard bond given on a trafficking offense because of potential penalties. Taking into account the totality of circumstances, I will set bond at $50,000. And sir, you're not to possess, ingest, or consume any controlled substances without a prescription. I also find probable cause on the DUI or driving under the influence, and your bond in that case will be $500. And while that DUI case is pending, you're not to possess or consume any alcoholic beverages or go to any bars. And your next court date will be provided.
Thank you, sir.
Thank you.
Have a great day.
Thank you. Thank you, Mr. Whedon.
Thank you, Judge.
Let's see. Not the ones that I reviewed. Let's see. I know we pulled stuff out, but. Ones I reviewed should have stickies all over them. Tell you what, sir, I'm Judge Epperson. How you doing? Can you tell me your name?
Robert Stir.
Last name?
Stir. S-T-U-R-R.
Stir.
In the misdemeanor DV pile.
All right, and presumably you're Olivia Matisse? Okay. Ms. Matisse, you're going to need to speak directly into that microphone, okay? I have reviewed the police report. I do find probable cause for the offense of assault. Ms. Matisse, because you're the alleged victim, you have the right to be heard briefly today on conditions of release and bond, such as any fear of the defendant you might have or not have, that type of thing. Did you want to be heard?
Yes, sir. Yes, Your Honor.
Okay, speak directly into the microphone.
Yes.
Okay, what would you like to say?
I'm not afraid. I don't want him to be kept. However, I would like to claim no contact for the next couple of days while I ensure a peaceful and smooth transition out of the home.
Okay. Ms. Tyner is from the State Attorney's Office. Ms. Tyner, did you have any questions?
I just lost the last name. I'm sorry. Do you want to have contact about the child during those few days? Would you be okay with third-party contact about the baby?
Is third party the only option?
I think there's some apps you can use where it's only through texting, like Talking Parents. There's similar apps like that, but maybe just like only written communication. No in-person or over the phone. Would that be acceptable?
I'm fine with texting him personally.
Your Honor, we'll leave that up to your discretion, and we would ask for a no contact except for regarding the child and child care, and that to be either done through a third party, Talking Parents, or text message only.
Mr. Dawson?
John Dawson from Mr. Stir. So from my understanding, you're going to be leaving the residence that you share and moving somewhere else?
Correct. I had originally booked a flight for the 14th. After I leave here right now, I'll be finding another flight within the next couple of days.
Okay, so you're moving out of state?
Yes.
Okay, so you're comfortable with him returning to the residence?
Oh, it's his home, absolutely.
Okay, that's my only question.
All right, I'm setting bond at $500. Mr. Stir, until further order of the court, you're to have no contact whatsoever with Ms. Olivia Matisse. No contact means none. I know there was some discussions about third-party contact, but until further order of the court, no contact. Also, you must not return to 8112 Poinciana Boulevard. However, I'm sure you have personal belongings there, clothing, toiletries. I will grant a one-time return with the assistance of the Sheriff's Office for acquiring those belongings. I understand that Ms. Matisse may plan to move soon, And so you can talk to your attorney about getting a modification to that in the coming days, but for now, there's to be no return to 8112 Poinciana Boulevard, and you must not possess any weapons or firearms. Your next court date will be provided, and the public defender is provisionally appointed, or actually is appointed to represent you. Correction. All right, Mr. Stir, I believe your income is approximately $80,000 a year, is that correct? And you have one dependent? Two? All right, well, you do have the right to a lawyer, but you're going to have to hire your own attorney if you're going to be represented. Mr. Dawson is here today standing in and has graciously provided some assistance, but moving forward, you'll need to hire counsel if you're going to be represented. All right? Good luck. Thank you. Thank you, Ms. Matisse. Okay, so we're ready for Gene Faustin. Whenever corrections is ready for Gene Faustin, this will be a Creole interpreter. All right, we have, I believe we have our Creole interpreter on the line. Can you hear me? Oh, not yet. All right, good afternoon. Do we have our Creole interpreter there? This is Judge Epperson. Do we have our Creole interpreter?
Yes, hello. I'll be your Haitian Creole interpreter today. My ID is 359766, and my name is Kelsey.
Okay, and if you can just speak up with a strong voice, I'll go ahead and swear you in. If you could raise your right hand to be sworn. Do you solemnly swear or affirm that you will faithfully translate from English to Creole and Creole to English to the best of your ability, so help you God?
I do.
Okay, we'll go ahead and get started. Good morning, Mr. Faustin. I'm Judge Epperson.
Morning, sir.
Bonjour, Monsieur Faustin. Moi, c'est Juge Epperson.
I've reviewed the police report and I find probable cause for aggravated assault, battery, domestic violence, and hindering communication to law enforcement.
Alors, moi, lisez rapport police là. Moi, ouais, bien cause probable pour violence domestique, pour information contre la police et pour battre grave.
Okay.
On count one, aggravated assault, I'm setting your bond at $15,000. On count two, battery, domestic violence, I'm setting your bond at $1,000. And on count three, hindering communication to law enforcement, setting your bond at $1,000.
Alors, pour premier cas, attaque grave là, aggravée, moi, mettez bon pour $15,000. Deuxième, nan, domestique, violence domestique, là, $1,000. Troisième, nan, ou bien information pour pas bailler la police information, $1,000.
Okay.
You must have no contact whatsoever with Gino Exantis. That's Gino Exantis, no contact.
Puis on a contact plutôt avec Gino Exantis.
You must not return to 3916 Scottsboro Court in Orlando.
Puis on retourne dans 39 Scottsboro Court à Orlando.
You must not possess any weapons or firearms.
Faut pas qu'il y ait aucun arme sous.
And if you're going to have an attorney, you will have to hire your own, as you don't qualify for the public defender.
Et si ou pas gagner un avocat, faut gagner avocat sur compte personnel ou parce que ou pas éligible pour défenseur public là.
Your next court date will be provided.
Prochain date tribunal là, y a pas roulé.
Thank you.
Merci.
Right. And thank you to our interpreter. We'll go ahead and excuse. Appreciate it.
Thank you so much for using our services. Have a great day.
All right, and do I need to call for that? Call the Spanish. Okay, so let's call and we'll.
Good morning, Your Honor. This is Bresno Leon, certified Spanish interpreter, previously sworn.
All right, Mr. Leon, good morning again. And the defendant is wearing the headset. Good afternoon, I'm Judge Epperson. Can you please tell me your name?
Your Honor, will you press the button to let the victim in?
All right,
Bellanira Gomez.
okay. And I believe we might have Ms. Angelina Griffin here. Are you Angelina Griffin?
Yes, sir.
All right, Ms. Griffin, I know that you're the daughter of Ms. Gomez, and you're also the alleged victim. So you do have the right to be heard today concerning bond and conditions of release and how you feel about that.
So I'd rather her be released. I'm not pressing no charges. You know,
Okay?
my mother's never been to jail a day in her life, and this is just a situation that got out of hand. And I originally called the police just to get it, peaceful, just to make it
Then
end.
just to get what?
To resolve the solution and make it peaceful. Just for her. I never meant for her to get arrested.
State have any questions?
Would you feel safe with your mother returning to the home?
I currently moved out. She had kicked me out, so me and my boyfriend, we are currently staying with his uncle. The only things I do ask for is I still have a few belongings in a closet, if I can go back and get that. And also, I did currently pay her bills. The argument was over bills. I paid her yesterday, and I was just, legally, if someone pays rent, either you gotta let them stay the whole month or you gotta refund the money back, and that's the only thing that I want.
Okay, so you're not afraid of her?
No, I'm never afraid of my mother.
Okay, no further questions.
Mr. Dawson, any questions?
Yes. Do you wish to maintain contact with your mother?
I mean, that's up to her. I mean, yes, that's at the end of the day, that's my only parent I have. So it is solely up to her.
Okay, thank you.
All right. Does the defendant qualify for straight pretrial release?
Yeah.
Ms. Gomez will be placed on pretrial release supervision. And Ms. Gomez, you're not to have any hostile contact with Ms. Angelina Griffin. No hostile contact prohibits any acts of violence, but also any threats of violence. You must show up for your court appearances if you have any scheduled. And follow the rules of the pretrial release program. Thank you. A public defender is appointed in this matter based on the application. Defender appointed, next court date to be provided. And so the next person I would expect would be Mezadou, maybe? Mezadou. All right, sir, how are you doing?
I can't complain. How about you?
Good. Can you state your full name?
Malik Nazir Mezadou.
All right. I will appoint the public defender to represent you in this case. I did review the police report, and I do find probable cause for count 1, violation of an injunction or no contact order, and count 2, aggravated assault with a firearm. One moment.
Excuse me.
All right, I had an indication the defendant may be on probation, is that correct?
Yes, Your Honor, he is on state probation.
All right, the allegations supporting probable cause are very concerning. Your bond on count one, violation of the no contact order, will be $5,000. Your bond on the aggravated assault with a firearm will be $15,000. Should you make bond, you're to have no contact whatsoever with Kenia Mathis, no contact with Lamaris King, no contact with Zoe Mezidou, no contact with Zuri Mezidou, must not possess any weapons or firearms, must not return to the location of 12,000 Fountain Brook Boulevard, must not possess any weapons or firearms, and the court finds an on-view violation of probation. And that case number for probation, can someone help with that? I don't see it.
It's a Miami-Dade case.
Oh, well, I'll just, there'll be a hold in Miami-Dade to be notified of an on-view violation. All right. Thank you, sir.
Okay, so sir, I have one question.
Okay?
With the bond, it doesn't make any sense I pay it, right? Because the Miami-Dade still will just have to come get me.
Well, Miami-Dade's going to be notified that I made a finding of an on-view violation of probation. And I'm going to order, I'll give 96 hours for Miami-Dade to take action. If they don't, you'd be entitled to come back before the court. All right,
Okay, so
thank you.
do I pay the bond and wait the 96 hours?
You'll need to talk to a lawyer about that. I can't give you legal advice, all right?
Alrighty, thank you, sir. You have a good one.
You too. All right. All right, hello, ma'am, your name? Okay, and I presume that corrections let me know if anyone's out there on the case. All right, I will appoint the public defender to represent you in this matter. I have reviewed the police report. I do find probable cause for burglary of a conveyance with a battery therein. This is actually an offense which is considered a PBL, standing for punishable by life as a maximum sentence. I'm setting your bond at $25,000. Should you make bond, you're to have no contact whatsoever with the victim. Now, state, I would make inquiry of everybody. The police report kept referring to the victim as victim one, and I didn't see the name. I don't know if you have that or anyone else does. I don't know.
The victim enacted Marcy's law, so that's why it's listed the way that it is. It's so that the victim information doesn't show up on the back of the affidavit. And then just for the record to preserve it, that is a PBL, so the state would request you be held at none.
Okay. All right, so that's a $25,000 bond, no contact whatsoever with the alleged victim in this case. I saw you do this, and I'm sure you're aware of who that is, so you're to have no contact with that individual. You also must not possess any weapons or firearms, and you must not return to 2934 Park Meadow Drive. You have legal counsel, the public defender's appointed, and your next court date will be provided. All right, thank you.
Say something?
Yes, into the microphone there.
I'm sorry. I want you to know that the letter from the officer, it's absolutely untrue about what exactly happened. The lady, she's my co-wife. It's three of us. We're all married to one husband.
Mhm.
I was not at her place of residence. I met her outside of her gate, outside of the gate of her residence, because she came to my other co-wife's place of residence to pick up my husband.
I have a word with you for once. Speak to me for a second.
All right, a couple of things. Number one, you're presumed innocent of these charges, and the state has to prove them beyond all reasonable doubt. There's often two sides to a story. I have to make my judgment for probable cause based on what's in the sworn affidavit, all right? So you'll need to talk to your lawyer about those things. Have a good day. All right, Mr. Hall? Sir, if you could state your name. Hello? John David Hall?
Yeah, Hall.
All right, sir, I'm Judge Epperson. Good morning. I've reviewed the report. You've been arrested on failing to appear for court on a trespass charge. The judge did give you a bond of $500. It was actually a pretrial conference date.
Today, I mean, the newest charge, right?
You have a bond of $500.
Yeah.
All right, and your next court date will be provided, and the public defender's office will represent you on this case. All right?
Yeah, I didn't get what would you say? He asked for who?
I didn't say anything about that.
You said, no, failure to appear.
Yes, you were arrested for failing to appear for an October court date on a trespass charge. And so you have a $500 bond on that case, and you'll have to
They ended that here.
you'll have to talk to your lawyer about that, but this hearing is finished. Okay?
I don't know where y'all got that, man. My bag right there.
Good afternoon, sir. I'm Judge Epperson. Can you tell me your name?
Hiram Lionel Cordones.
All right, sir. I did review the police report, and I do find probable cause for defrauding an innkeeper, which essentially is a theft from a 539 establishment, the La Quinta Inn. Your bond is $500. You're not to return to the La Quinta Inn at 5837 Americana Way. The public defender's office is appointed to represent you, and your next court date will be provided. Thank you.
You're welcome.
All right, good morning. I'm Judge Epperson. Your name? All right, Mr. Bellew, you've been arrested for possession of drug paraphernalia. I've reviewed the police report. I find probable cause for that offense. The public defender will be provisionally appointed to represent you. There's another matter, just one moment. Was that it? Yeah. All right, and then there's a second case, open container of an alcoholic beverage. One moment. I do find probable cause for that as well, and your bond will be $250. Public defender represents you on that as well, and you'll receive your next court dates. Thank you. All right. Hello, sir. Good morning. I'm Judge Epperson. Can you please state your name?
Gregory O'Neill.
All right, Mr. O'Neill, I have read the police report in this case. I do find probable cause for the offense of trespassing. You do have, I'm going to give you a bond, $500, and you're not to return to Orlando International Airport. You've been trespassed from that location. All right, thank you. Public defender appointed provisionally. All right, hello, sir. Your name?
Michael Lee Bennett.
All right, Mr. Bennett, I'm Judge Epperson. Good morning.
Good morning, sir.
I did read the police report, and I find probable cause for the offense of open container of an alcoholic beverage. I will appoint the public defender to represent you so you have legal counsel. Fortunately, you're out on bond on a similar offense, case 23 MM1708. So I'm going to revoke your bond and give you a bond of $750 on that case based upon this new law violation. All right, thank you. Your next court dates will be provided.
Excuse me, Your Honor. What's the bond for the open container charge?
$250, I believe is what I announced. Yeah, $250.
Thank you.
All right.
I can't bond out?
No, you can. You can.
I can't?
You can.
I can't bond out.
Mm-hmm.
So he revoked the other bond, so
All right, I believe that's Mr. Davila. Good morning, sir. Can you please tell me your name? Kenneth Davila? All right, Mr. Davila, I do find probable cause for violating Orlando City ordinance, disorderly conduct. Your bond is $250. The public defender is appointed to represent you in the case, and your next court date will be provided. All right.
Your Honor, the state attorney has provided a credit time served offer for this case.
All right. Does he wish to accept that? You need a moment to talk with him?
Yes, he wishes to do that, Your Honor.
All right, Mr. Davila, if you could please raise your right hand to be sworn. Do you solemnly swear the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Sir.
You can put your hand down. Mr. Davila, you have the right to a jury trial. By pleading guilty, you're giving up that right. Do you understand that? You have to answer out loud.
Sir.
Are you right now, today, under the influence of any drugs, alcohol, or medication? I have to hear you.
No, sir.
All right. And if you're not a United States citizen, this could subject you to deportation. Do you understand that? The allegation is disorderly conduct for soliciting in the roadway at an intersection. How do you wish to plead?
Yes, guilty.
Can't hear you. All right. Are the parties stipulating to a factual basis?
Yes, Your Honor.
Yes, defense stipulates.
Mr. Davila,
Sir.
I accept your guilty plea, adjudicate you guilty, and sentence you 2 days in the Orange County Jail. Court costs are $227, $50 cost for the services of the public defender for a total of $223. All right, so the total is $273. And I'm ordering that you pay that within 90 days to the Orange County Clerk of Court. And don't return to that location at the intersection of Conway Road and Curry.
I don't have a job. I don't even have a place to live. How am I going to pay $270?
All right.
I was trying to get money for breakfast that day, and they...
All right, you just have to try to do that in a way that doesn't violate the city code, all right? So you can't do it at an intersection. It endangers yourself, and it's also an annoyance to the public. All right? At least it is to me when I see it. Thank you. We'll move to the next case.
What happened?
All right, sir, your name?
Gafar Ayadel.
All right, one moment. I will appoint the public defender to represent you in this matter. I have reviewed the police report. I do find probable cause for the offense of battery, domestic violence. I'm setting your bond at $1,000. Should you make bond, you're to have no contact with Ricketta Patterson. You must not return to the Holiday Inn. Must not return to the Holiday Inn located on Continental Gateway Drive. You must not possess. You must not possess any weapons or firearms. Do you have personal belongings at the Holiday Inn still?
No, actually, we came here for vacation. So
Right. Okay. Or,
from Minnesota.
all right. Your next court date will be provided. Thank you.
Okay. Thank you, sir.
Thanks. All right, Ms. Berry, if you could state your full name.
My name is Janae Lee Berry. Good morning, Your Honor.
Good morning. I have reviewed the police report. I do find probable cause for the offense of battery, domestic violence. One moment. Any contact with victim Adonis Miller that could be reported from anyone? Any contact? No.
Your Honor.
All right, I'm going to set bond at $250. Should you make bond, you're to have no hostile contact with Adonis Miller. Are you paying attention? All right,
Yes, I am, Your Honor.
no hostile contact. That means obviously no acts of violence, but also no threats of violence. You must not possess any weapons or firearms, and you must not return to the Holiday Inn located at 12005 Regency Village Drive. If you think you have personal belongings there, such as clothing or toiletries, you can return one time with the assistance of the sheriff's office for getting those belongings. Did you have a question?
I do have a question, Your Honor. Me and him have been together for 2 years, and he does have my phone, he has my glasses, and he does have my money to bond me out. The police officer gave him everything yesterday because he didn't press charges, but I do see that there's a no contact order. I don't really have any family in Florida,
It was
so
a no hostile contact order, so you can contact him. It's just a no hostile contact order,
okay,
all right? And if you have any questions about that, you can talk to your lawyer. It just means no violence, no threats of violence. You have to be well behaved.
okay. So he's able to come in and post the bond?
Nothing prevents him from doing that based on what I've ordered. Yes.
Thank you, Your Honor.
Have a good day. All right, good morning. Your name?
Alessandra Branco.
All right, Ms. Bronco, I will appoint the public defender to, actually, you don't qualify for the public defender's office.
Okay.
Let me just ask one question here. All right, so I will appoint the public defender to represent you. This is Mr. Dawson, who's standing here to your left. I have reviewed the police report. I do find probable cause for battery domestic violence. Just one moment. I'm setting your bond at $500. Should you make bond, you're to have no contact until further order of the court. You're to have no contact with Thomas Evans. You're also not to return. I'll let you, if you'll listen to me first, okay, before you sign that, and then I'll give you an opportunity to be heard. Ms. Bronco, until further order of the court, you're not to return to 3069 Capri Isle Way. Now, I realize you probably have clothing, personal belongings there that you need, perhaps items for work. I'll grant a one-time return with the assistance of the sheriff's office to acquire those belongings, and you can talk to your lawyer about possibly getting that modified. All right, you cannot possess any weapons or firearms, and again, the bond is $500. Did you have a question?
Hey, Your Honor, I don't have anywhere to go.
All right.
My children are there. I would like to see them. And
All right. You're going to have to talk to your lawyer about going before the trial court in the coming days to get to seek a modification if the court finds that reasonable. These are simply the orders that apply right now until any further orders of the court. All right. Good luck. Thank you.
thank you. I have to sign this.
All right. Good morning. Your name, ma'am?
Kathleen Granizo.
All right, I'm Judge Epperson. I have reviewed the police report. I find probable cause for battery domestic violence. Setting your bond at $250. Should you make bond, you're to have no hostile contact with John Cunningham. No hostile contact prohibits any acts of violence, but also any threats of violence. You're not to possess any weapons or firearms. And until further order of the court, you're not to return to 3280 Soho Street in Orlando. If you have clothing, personal belongings, I would grant a one-time return with the assistance of the sheriff's office. Your next court date will be provided, and the public defender is appointed.
Okay, thank you.
Thank you. All right, Ms. James, if you could state your full name.
Janita Yvette James.
All right, Ms. James, I will appoint the public defender to represent you in this matter. This is Mr. Dawson to your left. I have reviewed the police report. I do find probable cause for violation of an injunction. I'm setting your bond at $500. I'm ordering that you abide by all injunctions, and I'm ordering that you not return to 5461 Hansel Avenue, and that you have no contact with Valeria Rashid. Your next court date will be provided. Yeah, had a question?
Oh, okay. I have belongings there. My son's belongings is there as well. I know I spoke with the officer that brought me here, and she said if I needed to go there, and she would take me.
Okay, an assist order will be granted. You can return one time with the assistance of the sheriff's office for acquiring those belongings.
Okay, so just the sheriff's office? 'Cause
Yes.
she's from the city of Edgewood. That's
No, you need to contact the sheriff's office. All right, thank you. If they want to hand that off to another agency, I don't have any objection, obviously. All right, sir, your name?
Christopher Better.
All right, I believe we might have Ms. Lona Rodriguez present. All right, Ma'am, if you could step right up to the microphone, and if you're going to speak, you'll need to speak directly into it. Can you tell me your name?
Lona Rodriguez.
Ms. Rodriguez, you are the alleged victim, so you have the right to be heard today. What would you like to say?
I have a mental disability and I'm not feeling that good right now. But what I want today is a restraining order.
Okay. Did you say restraining order?
Yes.
Yes. State, did you have any questions?
Ms. Loma, do you want to have contact with Mr. Vetter?
No.
Are you afraid of him?
Yes.
And do you two live together?
Yes.
No further questions from the state, Your Honor.
Any questions, Mr. Dawson?
I have no questions, Your Honor.
All right, Mr. Vetter, having found probable cause for domestic battery, I'm setting your bond at $1,000. Should you make bond, you're to have no contact whatsoever with Ms. Lona Rodriguez. No contact means none, no emails, no phone calls, no third-party communications. You also must not possess any weapons or firearms, and you also must not possess or consume any alcoholic beverages or go to any bars. All right, your next court date will be provided, and the public defender represents you in this matter. All right, thank you. Did I not mention that? Oh, it's because it happened at Oak Creek. Let's see. Didn't happen at the location. Obviously, he has no contact, so. Yeah, good question, no. All right. Good morning, ma'am. If you can tell me your name, please.
Zebanisa Ali.
All right, Ms. Ali, I'm going to afford the state 24 hours. It's an allegation of a grand theft of a motor vehicle based upon a rental agreement violation. Material to a finding of criminal intent would be a little more details with respect to the rental agreement. In other words, there would be a difference between someone being a few hours or a day behind versus a month, and there's no indication. It just says a report of a grand theft.
Yes, sir.
Based on a rental agreement. So you do have a bond in this case right now of $1,000.
Yes, sir.
I'm giving the state 24 hours to supplement the record on probable cause for a grand theft motor vehicle. So this will be reset for tomorrow. All right, thank you.
So that means no pre-release?
Sir, you can step up. You can please state your name.
Marcus Del Campo.
All right, Mr. Del Campo. There are 7 listed charges. The court finds probable cause for 2 of those. I find probable cause for, just a minute. Actually, I do find probable cause for fleeing and eluding a law enforcement officer, which is count 1. I also find probable cause for count 7, which is willful and wanton reckless driving. I'm going to give the state 24 hours to supplement the record with respect to the controlled substances charges 2, 3, 4, 5, and 6. The reason being, I believe there were 2 occupants in the vehicle. The items were not in the act, were not on the defendant's person, but were on the theory of possession would have been constructive, and so the officer can supplement the record with respect to dominion and control and the elements of possession. On the fleeing and eluding, your bond's going to be $5,000. That's count 1. On the reckless driving, it's going to be elevated from $500 to $5,000. And the bonds will remain as they've been set until tomorrow. I'm giving the state 24, so I'm just deferring a probable cause finding on 2 through 6. Your bond on count 2 is $1,000. Your bond on count 3, paraphernalia, is $1,000. Your bond on possession with intent to sell is $15,000. Your bond on possession offense in count 5 is $15,000. Your bond on the possession charge in count 6 is $15,000. Again, 24 hours on 2 through 6. Public Defender's Office is appointed to represent you, and your next court dates will be provided. Thank you.
Thank you.
All right, good afternoon. I'm Judge Epperson. Can you tell me your name?
Hey, how you doing, Your
I'm
Honor?
fine. Your name?
It's my name is Miss Gordon. Is it okay if I speak today?
Yeah, well, briefly, just give me a moment to speak first, okay?
Oh, yes, Your Honor.
You are Ashia Gordon?
Oh, yes, that is me.
All right, Ms. Gordon, you were arrested for failing to appear on a case. The underlying charge is possession of a controlled substance, and the issuing court set your bond at 0, which is often the case when it's a failure to appear. There was a pretrial conference on November 15th that you were noticed to appear for.
I had no knowledge.
Just don't interrupt me, please. I will appoint the public defender to represent you in this matter. This is Mr. Dawson to your left. Did you want to be heard?
Yes, Your Honor.
Go ahead.
I had no knowledge of this court date, Your Honor. This is my first time ever coming to court in Orlando. I'm not from here, and I would like to go home so I can go to my job interview tomorrow, and I promise I'll make it to the next court date.
All right, that is definitely information you would want to bring before the trial court that issued the warrant. I'll tell you this, the judge doesn't issue a warrant unless the judge looks in the file and has reason to believe that you received notice for the hearing. So you'll need to get with your lawyer about filing a motion so that you can correct that.
Oh, okay.
Thank you. All right, good afternoon, ma'am. If you can tell me your name.
Alma Marte.
All right. Ms. Marte, I do find probable cause for possession of methamphetamine. Your bond will be $1,000. Unfortunately, you are presently out on bond on a similar charge, possession of methamphetamine. Your bond will be revoked in that case, and you'll be held on a 0 bond. That's 23 CF 159734. Public defender appointed to represent you in these matters, and your next court date will be provided. Thank you. All right, hello, sir. I'm Judge Epperson. Good afternoon. Your name?
Shanta Matthew.
All right, sir, I have reviewed the police report. I find probable cause for the listed offenses: grand theft of a motor vehicle, count 1, possession of methamphetamine, count 2, and count 3, resisting an officer without violence. Just one moment. All right, your bond will be $1,000 on counts 1 and 2, and $500 on count 3, for a total of $2,500. The public defender is appointed to represent you in these matters, and your next court date will be provided. And you're not to possess or ingest any controlled substances without a prescription as a condition of your release.
Okay.
Thank you. All right, on the Mincy matter, I do find a probable cause for possession of methamphetamine. Bonds 1,000 will remain 1,000. All right, are you Mr. Morioka?
Your Honor, I believe on Mincy, doesn't he have 3 cases?
Thank you, yes. Okay, so probable cause on the possession of methamphetamine, and then he has failures to appear for which he'll remain on no bonds in 22 CF 10082, and failure to appear, which he'll remain no bonds 23 CF 7488. Yeah, thanks. All right, Mr. Morioka. All right, sir, you've been arrested on a warrant for which a court has already determined probable cause for 5 listed offenses. I'll briefly just inform you of those. First of all, trafficking in amphetamines. Your bond is $100,000 on that charge. Trafficking in methamphetamines, your bond's $250. Possession of cannabis, $250. Possession of cocaine, $250. And possession of tetrahydrocannabinols, $250, for a total of $101,000. You don't qualify for the public defender, so you'll have to hire your own attorney if you're going to be represented. And your next court date will be provided. And as a condition of release, if you make bond, you're not to possess, ingest, or consume any illegal substances or any controlled substances without a prescription. Thank you. Hello, sir. Your name?
Rollins, sir.
Vince Rollins?
Sir.
All right, I will appoint the public defender, Mr. Dawson.
I have a probable cause argument here.
All right?
For this case, I don't think there's actually a presumptive positive for MDMA in the police report.
All right, state.
Yes.
Your Honor, the only one I have tested was the cocaine, so I do see that there was a presumptive positive for cocaine, but I don't see any for meth.
Okay.
Nope, in possession of nothing.
My position would be that the controlled substance is the cocaine.
All right, I had made a preliminary finding when I reviewed the case that I was going to afford the state 24 hours on a separate issue, actually, Mr. Dawson, and that is defendant's knowledge and dominion and control over the substances based upon the circumstances in the case. So I will give the state 24 hours to supplement the record on the possession, showing the defendant's dominion and control over the substance and knowledge. All right? So, sir, you do have a bond right now of $1,000, and the state's going to get 24 hours to supplement the record on the question of probable cause. Thank you.
Thank you. Thank you, Your Honor.
Have a good day.
But it wasn't no problem.
We'll see. All right. Mhm. Hello, sir. I'm Judge Epperson. How are you?
Hi, sir.
Your name?
James Roosevelt C.
All right, Mr. C. I do find probable cause for possession of a controlled substance. Your bond's $1,000. Unfortunately, you're out on bond on a grand theft, and that's case number 23 CF 15957. And because of the probable cause finding of a new law violation, your bond is revoked on that case. That'll be a zero bond. The Public Defender's Office is appointed to represent you in these matters, and you'll get your next court dates. Thanks.
Far as the bond go, I'll have a bond hearing.
You can talk to your lawyer about having a bond hearing. Yes, sir. All right, thank you. All right, sir, your name?
Samir Walden.
All right, Mr. Walden, I have reviewed the police report. I do find probable cause for aggravated assault. I'm setting your bond at $2,500. You're to have no contact with Jerome Ramos. That's the alleged victim in the case. And you're not to return to the Wyndham Hotel on International Drive where this allegedly occurred. You're not to possess any weapons or firearms. The Public Defender's Office is appointed to represent you, and your next court date will be provided.
Okay.
Thank you.
I have a question. I've never, he said that in the report, he said that he previously told me to get off the property. I've never seen that man a day in my life, sir.
Okay, well, that's something you and your lawyer would definitely want to discuss.
Okay.
Thank you. Have a good day.
Thank you, you too.
All right, sir, your name?
True Wells.
All right, Mr. Wells, good afternoon. I'm Judge Epperson. I have reviewed the police report. There's 4 listed charges. I find probable cause for 2 of those. First of all, I find probable cause for count 1, fleeing and eluding law enforcement officer. I find probable cause for count 4, which is carrying concealed firearm. I don't find probable cause for 2 and 3.
Your Honor, if bond's going to be set on the 1 and 3, the state's not going to request an additional 24 hours.
Okay, I'm going to set, it's, 1 and 4. So on count 1, setting bond in the amount of $5,000. That's on the fleeing and eluding. On count 4, $2,500. As a condition of release, Mr. Wells, as a condition of release, you're not to possess any weapons or firearms. On counts 2 and 3, you'll be ROR'd for no PC. Your next court date will be provided. The public defender's appointed. Or actually, I'm sorry, the public defender is actually not appointed. Mr. Wells, based on your application, if you're going to have legal counsel, you'll need to hire your own attorney. All right, thank you. You can bond out today, yes. You have bonds on counts 1 and 4, and your ROR on counts 2 and 3. ROR means released. All right, thank you.
Thank you.
You bonded, okay? Okay, with respect to Thaddeus Williams, I do find probable cause for the listed offenses. Bonds will remain $1,000 and $2,500, and the Public Defender's Office will be provisionally appointed. All right, Mr. Williams?
Yes, sir.
Are you Thomas Williams?
Yes, sir.
All right, hello, I'm Judge Epperson. Mr. Williams, you've been arrested for a failure to appear on a trafficking charge. The case number is 23 CF 5508. The issuing court set your bond at 0. It will remain 0 at this time. The Public Defender's Office will be provisionally appointed to represent you. Yes, sir?
I'm homeless. I didn't have no knowledge of nothing.
All right, that's something that your attorney can bring before the trial court, but the court typically will not issue a warrant for failure to appear unless the court file reflects that there's been notice given.
I understand, but I just ain't have
Right.
an address. I'm homeless. Man.
All right, make sure you get with your lawyer on that. Sir, good afternoon. Your name?
Raymond Calderon.
All right, Mr. Calderon, I do find probable cause for trespassing at the Circle K. Your bond is $500.
Yes, sir.
Your bond is $500. I'm appointing the public defender provisionally to represent, or appointing the public defender to represent you. Unfortunately, Mr. Calderon, you've been released on your own recognizance on another trespassing case, and because of the probable cause I'm finding today, I'm going to revoke your ROR status in case 23MM8325. For now, you'll be held on a 0 bond on the case.
So I have no charges, no current pending charge cases.
Well, I know of 2 that are currently pending, and you have a $500 bond on 1. That's for the trespassing that just allegedly occurred at Circle K.
Yes, sir.
But your bond on the other trespass charge back on October 10th, you now have no bond on.
Yes, sir.
All right, thank you. Next court dates will be provided.
Yes, that's your.
All right.
Take the
All right, good afternoon, sir. Your name?
Heath.
Okay, Heath. Can you tell me your full name?
Willie Heath, sir.
All right, sir. I have reviewed the police report, and I find probable cause for providing false identification information to law enforcement while lawfully detained, which I realize is a separate charge. The officer wrote it up as 84302, but I do find probable cause for the same conduct under providing false identification while lawfully detained. That is under Chapter 834-901. But providing false identification information while lawfully detained. I'm setting your bond at $500. The Public Defender's Office, well, I don't have paperwork. Did he not fill it out? I don't have any paperwork for him. Are you interested in having a lawyer?
I thought I had one, right?
Okay, you do. I'm appointing the public defender to represent you, so you now have counsel, right?
Your Honor, the state has made an offer in this case. It's credit time served.
Okay. Have you had a chance to consult with your client?
I have not. Just one moment, Your Honor.
State, I know you have access to your computer there, I think, at least. Can you just get the statute for providing false identification information to law enforcement? I believe it's under 834.
I have the book.
Well, it might be under 901.
34. I think it is 34. And sadly, I'm faster with the book.
Mr. Heath's going to take the offer.
All right, one moment. Sir, please raise your right hand to be sworn. You solemnly swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
I do, sir.
All right, thank you. One moment. Maybe it's under 837. 837. All right.
I have 901.36, false name or false identification.
All right, I find probable cause under Florida Statute 837.055 for false information to law enforcement during an investigation. Mr. Mr. Heath, by pleading guilty, you understand you're giving up your right to a jury trial?
Yes, sir.
And if you're not a United States citizen, the plea would subject you to deportation. Do you understand that?
Yes, sir.
Did you sign this plea form?
Yes, I did.
All right. And Mr. Dawson, are you and your client waiving any deficiencies in the charging instrument?
Yes, Your Honor.
All right. How do you wish to plead to the charge of providing false information to law enforcement during investigation?
Guilty.
Party stipulating to a factual basis?
Yes, Your Honor.
Defense stipulates.
I accept your plea of guilty under 837.055. I will adjudicate you guilty and sentence you to 2 days in the Orange County Jail with credit for the 2 days that you've already served. Court costs are $223. There's a $50 cost for the services of the public defenders, total $273 to be paid within 90 days to the Orange County Clerk of Court. You have 30 days to appeal. You'll be released on this case today based on this disposition.
All right.
Thank you. Okay. All right, sir, hello. Your name?
Emmanuel Justin Henry.
All right, Mr. Henry, I will appoint the public defender to represent you in this matter. I do find probable cause for trespassing.
Yes,
I'll set your bond at $250, not to return to the Orange County Liquor Store. Actually, it's referred to as Orange County Liquors, located at 220 North Orange Blossom Trail.
Yes, sir.
And your next court date will be provided.
Your Honor, state has made an offer in this case as well for credit time served. I spoke to the client. He'd like to accept it.
All right, sir, please raise your right hand to be sworn. You solemnly swear the testimony you're about to give is the truth, whole truth, nothing but the truth?
Yes, sir.
You can put your hand down. Mr. Henry, by pleading guilty, you're giving up your right to a trial. Do you understand that?
Yes, sir. I sure do.
If you're not a United States citizen, the plea would subject you to deportation. Do you understand that? Under the influence of drugs, alcohol, or medication?
No, sir.
Did you sign the plea form? I'll give you an opportunity if you're in agreement. And if I accept this plea today, are you going to refrain from going to Orange County Liquors?
No, I will not.
You will not refrain, or you will not go?
I will not go.
Okay. All right, the accusation is trespassing at that location. How do you wish to plea?
Guilty.
Party stipulating to a factual basis?
Yes, Your Honor.
And defense stipulates.
I accept your guilty plea, Mr. Henry, and sentence you to 2 days in the Orange County Jail with credit for the 2 days that you've already served. Court costs are $223, $50 cost for the services of legal counsel. Grand total $273 to be paid within 90 days to the Orange County Clerk of Court. You'll be released on this case today.
Thank you very much, sir.
Have a good day. Okay. All right. Ms. Ivy? Hello. Can you state your first and last name?
Akila Ivy. Yes, sir.
All right, Ms. Ivy, I do find probable cause for trespassing
Yes, sir.
and setting bond, appointing a public defender to represent you. Mr. Dawson?
Yes, state has made an offer in this case as well. I have to inquire of the state. You had an abbreviation. It says no CH and then ROR. I know what ROR is.
Yeah, so Miss Ivy doesn't have any criminal history, and she was trespassing at Universal. I believe that she may have an opportunity to either keep her status as no criminal history or come up with a very agreeable deal with the state if she is released. So if she can't afford bond, I have no objection to an ROR.
All right. I do find probable cause for the trespass charge. The state has no objection to you being released on your own recognizance, so you'll be released on this case. You just have to make sure that you show up for all of your court dates and keep the court updated with any changes of address.
Sure. May I add something?
Yes.
Unfortunately, I believe I was the victim of abuse because the reason why my trespass was, I was considered a trespasser, was because I asked for a refund from 2 restaurants, and then they told me that I was soliciting, which is not true at all because there's on record and on video that I did go to those restaurants and have food that I did not eat because there was something wrong with it. And so I politely asked for a refund twice. However, then 5 security, and then I left. I was on my way leaving Universal City Walk, and then 3 to 4 police officers and security guards told me that I was trespassing, ignored everything I said, scribbled a trespassing note that I could not read, like the grounds of the trespass, and it's next to a bus stop. So I wasn't sure what was Universal Parks because I'm not from Orlando. And so I actually wasn't soliciting at all, according
Okay.
to Florida.
Well, you're presumed innocent, all right, and the state has to prove its accusation beyond all reasonable doubt, and that's certainly something you need to talk with about to your lawyer, but you're going to be released on this case today.
Thank you,
All right?
sir. God
Have a
bless.
good day. Thank you. All right.
All right. Thank you.
Thank you.
I also, here's another fun fact about me. I work for the University of Miami Law Clinic as a volunteer for their Speaking of Justice Youth Health Rights pamphlet. So I worked with some lawyers at the University of Miami when I was like in college. They were really, really kind. And so I'd also been interviewed for the Florida Bar magazine when I was younger to help get funding for foster children because I typically have a really good record. So thank you very much.
All right. Good luck.
Also
Thank you.
attending college at Barry University for MBA. Thank you.
All right. Have a great day.
All right, bye. Online.
Bye-bye. Sounds like she's applying for an internship, State. All right, Ms. Keenan, I presume?
Yes, sir.
Tell me your full name.
Sheena Devon Keenan.
All right, Ms. Keenan, I do find probable cause for a battery offense. I am appointing the public defender to represent you.
Yes, sir.
I'm setting your bond in the amount of $500. You're
Yes.
not to return to the Cricket Wireless store located at 314 South Orange Blossom Trail.
Sir, I'm innocent, and that's all I
Okay.
need to know. I'm going to trial on this case.
One other thing I need to tell you, you cannot have any contact with
Hey,
Kaylee.
sir, I don't know
Okay.
those people.
All right,
This is a serious matter, and these people sold me a phone. This is not the first offense. She's false identifying herself when we done met up with several occasions.
okay.
So I'm innocent to proven guilty, and I will contact my attorney. So therefore, I plead the Fifth Amendment in front of you today.
Well, you've already ruined that. All right.
I plead the Fifth Amendment. It's not a laugh situation. I'm
Right.
innocent. I'm pregnant. I'm
Okay.
losing babies. And just being real, sir, I would like to talk to my attorney.
Okay. Listen, one other thing, because I don't want you to get arrested.
Hey, sir, I'm not.
Listen to me. Listen to me. Don't have it.
Tell me what the signs are.
Don't have any contact with the person at that store that you disagree with, Kaylee Mitchell.
Sir, ma'am, they sold me a phone. This is
Okay.
sticker went on since November. So I'm the innocent one, and they're the evil ones.
All right, did you get that, Ms. Tyner?
Thank you so much.
All right. We'll move along.
Have any paper for me, anything?
I
Your
don't.
Honor, I missed the bond.
$500.
Thank you.
Thank you.
It was already decided there anyway. Thank you.
All right. Is it Mr. Villard?
Yes, sir.
Patrick Villard?
Yes, sir.
All right, sir. I will appoint the public defender to represent you in this matter. This is Mr. Dawson to your left. I have reviewed the police report. I find probable cause for theft. I'm going to give you a bond, $250. You're not to return to the Walmart located at 10500 West Colonial Drive.
Of course, sir.
And you are out on bond, as you know, on a possession of drug paraphernalia and carrying concealed weapons case. That's 23 MM 850 because of probable cause of a new law violation, which is an intentional type of offense. Your bond will be revoked in 23 MM 850. That'll be a zero bond. Your next court dates will be provided. All right, thank you. All right, Mr. Moody? Fine. All right, Mr. Moody, you've been arrested on a warrant from another state, I believe. Just a
Yes.
moment.
Yes, sir. I was coming from I was on vacation, but
Right, up- you're talking about here, right? Baltimore.
I was told.
Okay, so you've been, it's Towson County in Maryland, the state of Maryland. It's an outstanding warrant for an alleged robbery, and you have a zero bond on that. However, Maryland will have an obligation to pick you up within a reasonable time. They'll be notified of your availability. All right? Thank you. Oh, Thursday? All right, Thursday. All right, sir, your name?
Hey, Carl Nelson.
All right, Mr. Nelson, you've been arrested on a warrant out of Polk County for alleged violation of probation on a prostitution offense. Your bond is 0, but Polk County's notified of your availability for pickup, and that should be happening soon. Thank you.
Sir.
Okay, thank you.
I don't know if it helps to say this up front, but the state has made a credit time served offer for Mr. Daly.
Okay, and you can expedite this if there's an intention to have a stipulation to a factual basis?
Yes.
All right. Mr. John Daly,
Yes, sir.
please raise your right hand to be sworn. You solemnly swear or affirm the testimony you're about to give is the truth, whole truth, and nothing but the truth, so help you God?
Yes, sir.
You can put your hand down. Mr. Daly, your name and date of birth?
My name is John Nevitan Daly.
Were you born May 14th of 1949?
Yes. Yes, sir.
All right, sir, if you're charged with urinating in public in violation of city ordinance, by pleading guilty, you're giving up your right to have a trial. Do you understand that?
Oh, if I say that again, please, sir.
Okay, your attorney has suggested that you might want to plead guilty and accept the state's offer of time served.
Okay.
Is that true?
Oh, yeah. Oh, yes, sir.
Okay. By doing that, you're giving up your right to have a trial because you're admitting that you're guilty. Do you understand that?
Okay, sir.
The state and defense stipulating to a factual basis?
Yes, Your Honor.
Defense stipulates.
All right. Mr. Daly, I'll accept your guilty plea, adjudicate you guilty, sentence to 2 days jail with credit for 2 days in the Orange County Jail. You'll be released on this case today. There's court costs, which are non-waivable, of $223, $50 cost for the public defender, total $273. Order that be paid within 90 days. You have 30 days to appeal. Did you understand this?
Yes, sir.
Have a good day. All right, I'm assuming that maybe Ishia Evans bonded, okay? All right, thank you. Thanks. All right, sir, good afternoon. Your name?
Gary Michael Crawl.
All right, Mr. Crawl. One moment. All right, the court finds probable cause for an open container violation. City ordinance has $250 as your bond. Unfortunately, you're out on bond on a trafficking methamphetamine case and possession of cocaine. And when you're out on bond, you can't break any laws. You have to be law-abiding.
I wasn't out on bond. They dismissed it with a 33-day. They 33-day found it not. They decided about a chemical and they found it wasn't.
He's claiming that he was ROR'd because of failing to file within the time required. If that's the case, then there's it would be an ROR I would need to revoke if I was going to.
I'll double check.
That case is 23 CF 12699. Oh, he is ROR. Yeah, you're correct. You were, I see, it's ROR, not on bond. All right.
Your Honor, that hasn't been filed on. The state would just request a bond for this case and that you take no action on the out on bond case.
You mean the ROR case?
The ROR case, we haven't filed a notice of non-filing or anything like that yet, so
Okay.
I'm not sure the status, but since it's not filed on, there's no need.
All right, so I won't take action on that case, Mr. Crawl, but you have a $250 bond on the open container case. Public defender is appointed to represent you in this matter, and your next court date will be given.
Do I still have my charge with methamphetamine? I thought that was thrown out because it was found.
Well, the state has not filed charges yet, okay? So the police are not the ones who file formal charges, the prosecutor does, and they haven't filed yet, and they only have a certain period of time to do that, all right? They have 175 days within which to file, and if they haven't, you can talk to your lawyer about a dismissal.
So I have $250 bond. And when do I have another court date for open intoxicant?
$250 bond on the open container.
So I
That's,
can't plead guilty and go home today?
well, I don't know. I'm not a party. I don't negotiate cases. State, did you have a plea offer?
I wasn't gonna plea him because he's out on bond on the trafficking case, but given his history. No, he was just here on November 22nd for a city county ordinance violation. That means it's been less than 2 weeks since he was last here, so the offer will be 14 days.
Right, so I'm not gonna sit here and take part in negotiations, but if you want to convey the 14 offer to your client, see if he wants to do it.
14 days.
Right, sir, please raise your right hand to be sworn. Do you solemnly swear or affirm the testimony you're about to give is the truth, whole truth, and nothing but the truth, so help you God?
Yes.
All right, you can put your hand down. Now, sir, do you understand by entering this plea that you're giving up your right to have a jury trial?
Yes, sir.
And if you were not a United States citizen, it could subject you to deportation. Are you satisfied that you've had enough chance to talk to your lawyer about the decision?
Yes, sir.
I've informed you of the charge. Can I see the report again? I gave it to you, I think. Yeah. Thank you. All right. How do you wish to plead to the open container violation that's alleged?
Guilty.
Are the parties stipulating to a factual basis?
Yes, sir.
State stipulating?
Yes, Your Honor.
I accept your guilty plea as charged, adjudicate you guilty, sentence you to 2 days, sentence you to 14 days in the Orange County Jail, with credit for the 2 days that you've already served. Court costs are $223, $50 cost for the public defender, total $273. You have 30 days to appeal. Mr. Crawl, did you understand all of this?
Yes, sir.
All right, don't carry around open containers of alcohol. That way you won't get arrested for it.
Okay.
Have a good day.
I have a probable cause argument for this one.
Okay, I want to be transparent here. I need to review it. One moment. All right, Mr. Dawson, your probable cause argument?
Yeah, my argument goes to the fact that the open container was actually in a vehicle, so I think there's a question of it being on public property.
Saying public property is an element of the offense. Say that again?
Yes, the ordinance, as I read it, refers to like a public park or a street or something like that, and he was actually in private property.
All right, and State, Ms. Tyner?
Your Honor, I believe it should have been charged as open container under the Florida statute since he was in a vehicle. So we would ask for a probable cause there. The allegation is that I believe he was parked at the CVS. So we'll leave this one at the court's discretion. I don't see, well, I do see some convictions, but the last conviction was unrelated to alcohol. We just asked that Mr. O'Cauley not have open containers on the sidewalk or in his vehicle otherwise.
All right, well, since there seems to be consensus among council about the listed charge that the officer cited, I'll go ahead and ROR Mr. O'Cauley on this case. It'll be up to state as to what charge they choose to file if they choose. So I'll find no PC, ROR. Next court date will be provided, public defender appointed. Thank you. Thank you. Have a good day. All right, Ms. Reynolds, if you could state your full name.
Ebony Monique Reynolds.
All right, Ms. Reynolds, I'm Judge Epperson. Just one moment. Okay, I will appoint the public defender to represent you in this matter.
Your Honor, there's a credit time served offer for Ms.
Okay.
Reynolds.
The accusation is urinating in public in violation of city ordinance.
That's my first time, never dated.
All right, Mr. Dawson, do you know what your client wishes to do?
I don't. I just need to explain it to
Okay,
her.
I'll give you a
for-
moment.
credit. She wishes to accept the offer.
All right, Ms. Reynolds, if you could please raise your right hand to be sworn. You solemnly swear the testimony you're about to give is the truth, whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you can put your hand down. Ms. Reynolds, you have the right to a trial, but if you plead guilty, you're giving up your right to have that trial. Do you understand that? All right, and are you under the influence of any drugs, alcohol, or medication today?
No, no, sir, at that moment.
If you were not a United States citizen, do you understand this plea would subject you to deportation?
Well, I am. I was saying,
I couldn't hear you.
I sir, but I've been born and raised here all my life.
Okay.
Yes.
All right, well, that's, the accusation is urinating in public in violation of the city code. How do you wish to plea?
Guilty.
All right, and the party stipulating?
Yes, Your Honor.
Defense stipulates.
I accept your guilty plea, Ms. Reynolds. Adjudicate you guilty, sentence to 2 days in the Orange County Jail with credit for the 2 days you've already served. There's court costs that are mandatory, $223, a $50 cost for the public defender's office. I'll give you 90 days to pay to the clerk of court, and you have 30 days to appeal. You'll be released today on this matter, all right?
Yes, sir.
Have a good day.
Okay.
Okay, Ms. White?
Yes, sir.
There's credit time served offer here as well. And
All
she
right.
wishes to accept.
All right, Ms. White, the charge is possession or consumption of alcohol in public. Please raise your right hand to be sworn. You solemnly swear or affirm the testimony you're about to give is truth, whole truth, nothing but the truth, so help you God.
Yes, sir.
All right, you can put your hand down, your name and date of birth.
Deborah White, 12/07/1978.
All right, now you do have the right to a jury trial. Do you understand by pleading guilty, you're giving up that right?
Yes, sir.
If you were not a United States citizen, do you understand this plea would subject you to deportation?
Yes, sir.
Are you today or now under the influence of any drugs, alcohol, or medication?
No, sir.
I informed you of the accusation, possessing or consuming alcoholic beverages in public. How do you wish to plea?
Guilty.
Party stipulating?
Yes, Your Honor.
Defense stipulates.
Ms. White, I accept your guilty plea, adjudicate you guilty. 2 days in the Orange County Jail with credit for the 2 days you've served. Court costs $223, $50 cost for the public defender, a grand total $273, must be paid within 90 days. You'll be released on this case today, and you have 30 days to appeal. Thank you. I don't have any paperwork in front of me anymore. Have we actually run the whole thing? I know. All right, well, thanks, everybody. That's all of our cases. So as far as court's concerned, we'll go off record. I'm in recess.
Thank you, Your Honor.